You're listening to Explain That by Velocity Legal, the podcast that keeps business owners and professional advisors ahead of the curve in an ever-changing legal landscape.
In the last episode, we talked with Archana Manapakam about how businesses can protect themselves for tax liabilities due to misconceptions with Division 7A, whether loans, use of company assets, payments, debt forgivenesses. One thing we didn't talk about was unpaid present entitlements, and they are a minefield when it comes to Division 7A. The ATO's had long-held views about those unpaid present entitlements, and we've had a recent case called the Commissioner of Taxation and Bendel, which has exploded that ATO interpretation of unpaid present entitlements in Division 7A. Today, Special Counsel Archana Manapakam and I will unpack what's changed in light of this recent Bendel decision, why now is the time for business owners and advisors to reassess their approach to Division 7A and UPEs, and potentially what to do going forward. So welcome back, Archana.
Good to be back, Andrew.
Now, Archana, you're a bit of a tax nerd, as am I, as are all tax lawyers, I think. Did you get excited when you saw this Bendel decision come out?
I was very excited. I think we were all doing a countdown, waiting for it to drop around 2:30 on Wednesday the 19th, was it? Wednesday the 19th of February.
That'll be etched into your memory now.
Yes, pretty much.
It's a key date. It's sort of like when the Berlin Wall fell, or man landed on the moon, and then the Commissioner versus Bendel. It's up there with those.
I think so. One of the very well-known tax practitioner called it the most significant tax decision this century. Mind you, we're only a quarter of the way through the 21st century, but yeah.
Now, Archana, I'm excited about this Bendel decision too and its implications. So I'll try not to be too enthusiastic, but the case resulted in a loss for the Commissioner. The court said that, okay, UPEs, they are not loans. How have we gotten here? How are we here in a situation where we're celebrating this big case and marking it, next to the moon landing and the fall of the Berlin Wall?
Well, that's a good question, and it is a 15-year journey essentially. But to begin with, maybe we just explain what an unpaid present entitlement is.
Yep.
So basically, at the end of a year, financial year, a trust will often make trust distribution resolutions. So that creates a present entitlement, and until such time as it's paid, it's an unpaid present entitlement. Now, as we discussed in the last podcast, a loan made by a company to a shareholder or an associate of the shareholder can give rise to a deemed dividend.
Yep.
The Commissioner's view for the past 15 years, since I think it was 16th December 2009.
Got those dates etched in.
I do have those dates etched in, like the 19th of February 2025.
Yeah.
Since then, the Commissioner's view is that an unpaid present entitlement owed by a trust to a corporate beneficiary is a loan for Division 7A purposes from the company to the trust being essentially an associate of the shareholder.
So let's just take that as an example. We've got $100 of income to the trust, and the trust has then said, okay, I'm going to make someone presently entitled to that. I'm going to make it company entitled, and so then the company would get taxed on the $100 at the company tax rate.
Mm-hmm.
And you're saying that would create an entitlement there. Trust hasn't actually paid the money to the company yet.
Mm-hmm.
And the question is, what's the status of that unpaid present entitlement?
That's right.
Yeah.
So the law says that the provision of financial accommodation by a company to a shareholder and associate is a loan for Division 7A purposes. The Commissioner's view was that if that unpaid present entitlement isn't paid by the lodgement date for the tax return for the immediately following year, then it's a deemed dividend. So let's just take that back. So just say that in end of the 2023 financial year, the trust resolves to distribute some income, 100% to a corporate beneficiary. It holds on to that money. It doesn't actually pay that out. The following year, it's treated as a loan. So in the 2024 year.
Yep.
And if it's still not paid to the company by the lodgement date for the 2024 year, so that would be around May 2025, so May this year, that would be treated as a deemed dividend arising in the 2024 year. Very complicated stuff,
Yeah.
I know.
I sort of call it like a 2-year rule. So it's pretty much like from if within 2 years of the trust making the company entitled to money, it hasn't paid it, then you got an issue.
Yeah.
Yeah.
There's a situation where you haven't paid it, but they also say if you put it on the terms of a Division 7A complying loan agreement by that lodgement date of that immediately following financial year, then you won't have a deemed dividend. And also they had some things like what they call sub-trust arrangements, which we won't go into.
Yeah.
But those are the two things to bear in mind.
And that 2009, that 16 December 2009, that was a U-turn for the commissioner at that point, wasn't it? Because until that point, everyone thought and acted in the way that those unpaid present entitlements weren't.
That's right.
Weren't alone.
That's right. So, so basically, when the commissioner did this U-turn, he allowed for a quarantining of pre-16th December 2009 UPEs. So that didn't give rise to deemed dividends. You didn't have to put them on Division 7A complying loan terms or anything like that. But from that date, people have been treating them as giving rise as loans, and they've been relying on the commissioner's interpretation. And there's always been questions around whether that's actually a loan. They've been relying on that to take certain action. For example, putting it on Division 7A compliant loan agreements, maybe making Section 109RB applications for relief, or they might be amending assessments, or the ATO might have audited them, issued amended assessments, default assessments, penalty assessments. So a lot of adverse action has been taken against taxpayers because of the Commission's view.
And that's over 15 years. And as you said, there's been all these actions. And in your experience advising clients, I expect that, most, if not, a very high percentage would comply with the ATO's
That's right.
views because it's David versus Goliath almost.
That's right. So, if you're going to take on that view, you have to be willing to fight it in the courts, which is exactly what's happened in Bendel's case.
So now we've got the court decision that said that that's not a loan. Yeah. I guess sort of just in terms of that process, I want to get into some of the practical implications in a second, but where do you see that process going from here? Will the ATO appeal? What will there be further developments?
So the commissioner, I believe, has 28 days from the date of the decision. So I think that's until 19th March this year to apply for special leave to appeal to the High Court. So this is a full federal court decision. So if they're going to appeal, they have to go to the High Court. And the High Court, even if they get that application for special leave, they might not grant it. So there's a bit of a process involved. But because of that, we have a court decision now, and the ATO can't simply ignore it. So before this, there was an AAT decision, so a decision of the Administrative Appeals Tribunal, which the ATO has effectively ignored. So they issued so in the AAT decision, they also decided that it was not a loan. The UPE was not a loan for Division 7A purposes. The commissioner, the ATO, then issued what's called an interim decision impact statement, basically how they'll administer the law following this decision. And they've essentially said, we will continue to administer the law according to our view, which is that it is a loan. But any objections, so that's when you dispute an assessment, you go through an internal dispute resolution process called an objection process. We won't finalize those objections until this full federal court decision has been handed down.
So essentially everything's on hold, but we're not changing our views yet.
That's right. And they kind of technically could do that because a tribunal is not a court. So a tribunal is, we won't go into the technical, it's part of the executive, it's not part of the judiciary.
Can't ignore a court.
But they can't ignore a court decision.
Yeah.
So I would expect that they'll shortly be issuing a decision impact statement on the full federal court decision. We'll also have some clarity about the appeal process, but regardless of whether they go down that process, they are bound by that now. So you'd expect that objections will now have to be processed. They can't just leave them on hold as they have been doing.
Because that high court process might take, 6 months plus to play out, and, financial years are ticking over, lodgement times are ticking over. People have got to take action still, don't they?
That's right. So I think that now that we have a court decision, I think that, taxpayers, need to take some action. There are certain things that, if because of time limitations, for example, if you got generally, you got 4 years to amend returns and stuff. I think there's a 60-day period to technically to object against certain things. So you got time limitations, and you don't want to be out of time to be able to, challenge assessments that were based on an incorrect view of the law.
Yeah, particularly if you've sort of been audited and, you've said you've been sort of penalised by, and the ATO said something like, well, you didn't follow, our views have been clear and you didn't follow them.
Yeah.
It seems pretty unfair that if those views are now confirmed as not correct, that taxpayer should be penalised for that. That seems pretty unfair to me.
That's right. And now, as we talked about earlier, this has been going on for 15 years. So we've got a limited amendment period. But what about all those prior years? Will the commissioner allow, to open that up beyond that period?
Yeah, if there's an audit 6 years ago and they were slapped, with all these penalties, what would happen there?
Yeah. So, I think that now that we have this court decision, taxpayers should be seeking advice promptly to make sure that they can, reverse adverse decisions if they can, and also to seek clarity on their position or going forwards.
Yeah, well, I wanted to get to going forward. I mean, what about, situations where, let's say, 3 years ago, you had a UPE and, the everyone said, okay, let's do the loan agreement and put that in place, now, and that's over a 7-year period. Well, we're 3 years into it now. What do they do?
Yeah.
Come to you, but what do they do? Do they vary that? Do they yeah.
Yeah, it's a very tricky situation because it's not as simple as just forgiving that loan because it can give, even though a UP might not be a loan for Division 7A purposes, the forgiveness of a debt, and a UP is a debt owed to the company, will give rise to Division 7A consequences, subject to certain concepts like distributable surpluses, which we won't go into today.
So they can't just wipe it off, but perhaps they could quarantine it or not charge interest or do it in some
Yeah, they can do something.
Yeah.
They can probably vary it. So, it might still be a loan, but maybe you just got no interest or very nominal interest or something. You can change the term because it never had to be a Division 7A compliant loan agreement. So there are certain things that can be done, and taxpayers should be seeking advice on that.
So, Achana, in these situations, let's go back to that starting example. Trust has got $100 that comes in and it makes the company presently entitled to that. There's sort of two situations I usually see there. One is where that money stays in the trust, called a sort of a retention scenario, and the other one is where the money leaves the trust and goes somewhere else. Now, we have these other provisions called subdivision EA, and while everyone's jumping for joy about this Bendel decision, there are still some real complexities and nuances. So what's your take on that, and what does Bendel, assuming Bendel stays up and is held, what does that actually mean for advisors and business owners?
I'm glad you asked that question, Andrew. So the Bendel decision doesn't mean that UPEs no longer Division 7A consequences. It means that it's not a loan for Division 7A purposes, but it might still give rise to a deemed dividend under subdivision EA of Division 7A. I know the naming numbering conventions in this legislation are just hideous.
They should just start again.
They did try to start again, but they never completed the task of rewriting the legislation. But anyway, I digress. So in a retention, it's not very well understood, subdivision EA.
And that's because people haven't had to deal with it for the last 15 years, assuming the Commissioner's views are correct.
That's right.
Yeah.
So subdivision EA is quite complicated. Where funds are retained in the trust, so that retention scenario that you were talking about, there would be no deemed dividend in those circumstances.
So if I'm running a business through a discretionary trust and I want to use the corporate tax rate, make the present entitlement to the company, and so long as I reinvest the money in the business because it's tied up in stock or debtors or something else, then saying that, assuming Bendel's right, is now okay.
For Division 7A
For
purposes.
Division 7A purposes. Sorry.
We won't go into Section 100A just yet, maybe. But there won't be consequences under subdivision EA.
Yeah.
Okay?
Because the money hasn't gone out.
It hasn't gone out.
Yeah.
But if the money goes out, so UP owed to a company, and then the trust essentially loans that money or pays it out or confers some other benefit to another beneficiary, say, or another entity that's a shareholder or associate of the company, then that can give rise to a deemed dividend under subdivision EA. So retention, okay for Division 7A purposes, but if it's going out somewhere else, the value of it, including a debt forgiveness, then you got potential problems under subdivision EA.
So even though we've got a win on Bendel, it's still very difficult to navigate and a lot of complexities and probably perhaps even more complexities in some ways, would you say? Because with the ATO's view, it kind of makes it simpler in some sense that it's always a loan, but now it's, well, maybe you've got an issue, maybe you don't. Let's work through subdivision EA. Yeah.
That's right. So it is, you're not all home and hosed because of the Bendel decision. There is subdivision EA to consider. And that also means that the Division 7A implications can arise for a different entity under subdivision EA because it's under the Commissioner's view, the deemed dividend would have arisen for the trust and then it would have flowed through to any beneficiaries to whom the trust made distributions. Under this situation, the deemed dividend would arise to the entity to whom the funds essentially go out by way of a benefit. So
it's a direct passing rather than an indirect possibly.
Yeah.
But it could assess someone else. And then the loan agreement would be to a different party as well if you're going to do a loan agreement there as well.
Yeah, that's right. So not all home and hosed. And we've got some, even with the retention of funds, we've got something called reimbursement arrangements, Section 100A, which needs to be considered. The Commissioner's view is that it can give rise to consequences under that.
That's a scary provision in and of itself, but we won't
go into that. Yeah.
I want to go back to sort of the discussion about where this could go from here. Now, I know that many years ago, the government of the day did announce that they were going to bring UPEs in as loans. They said something like, we're going to treat all UPEs as loans. I know it's hard to predict, but where do you see, do you think the government's going to make an announcement? Are they going to change the law? Are they going to somehow make it all okay for the ATO? What do you think?
Yeah, so this is a Treasury consultation paper from 2018, October 2018, so nearly 7 years ago. And it looked like the changes were imminent and nothing's happened. But now, because of this decision, I think, and a lot of practitioners think, that it's going to come back on the cards. Now, we've got a federal election looming, 17th May?
Sometime in May, I think is the last date. I don't think it's been called yet, but I think it has to happen before the end of May.
Yeah, so sometime in May. So, it's subject to, I suppose, what's going to be the outcome of that election. But in terms of what was actually announced back in 2018, it was proposed that UPEs would be treated as loans in the year in which the present entitlement was created, and in which the UPE arose. And the only way that could be, that would give rise to a deemed dividend unless it was paid in full by the lodgement date for the year in which that UPE arose. So you don't get that extra year. You don't get that grace, right? So if it's arose in 2024, 30th June 2024, you got to pay it by the lodgement date of 2024 tax return, probably about May 2025. Alternatively, you could place it on the terms of a Division 7A compliant loan agreement. Now, the changes that were announced last year also included changes to the requirements for a compliant Division 7A loan agreement. The term was to be 10 years, slightly higher interest rate, I think 2%, about 2% higher. So it's 10% regardless of whether it's secured by a mortgage or not, 10 years. And a slight relaxation of the formality requirements. But basically, it's treated as a loan, and as per the usual loan provisions, you got to pay it by the lodgement date, or you got to put it on the terms of a Division 7A compliant loan agreement.
Yeah. And I imagine neither of the, not to dwell too much on the political part, but I imagine neither party probably wants this to be an election issue. And the reality is, it's a less than a 1% affected issue of itself. But I can't imagine that they're going to want to make this a big political issue for an election, and particularly with the High Court process potentially still to play out. Do you sort of see that it's probably, there might never be anything that happens for 6 months, and then it might be the new government or the existing government, they get back in, start to think more seriously about all those consultation papers and potentially reforming Division 7A, or at least codifying UPEs?
I think it's a wait and see piece. There are a lot of legislative reforms that have been on the agenda for the government of the day for many, many years. I think that the Bendel decision will throw Division 7A into sharp focus.
Yes.
However, it's a bit of a wait and see piece right now.
Yeah, and it's hard with that wait and see because, as you know, with your clients, they are coming to you for advice, and they want to know, there's this Bendel decision. What do I do? How do I do my returns? What decisions do I make? So you still got to act in the meantime.
And also, there's a question, if there is a change, will it be retrospective? Will it apply from past years, or will it apply going forwards? Retrospective legislation usually is quite draconian.
It's very unpopular.
It's very unpopular, very draconian. The consultation paper, I think, talked about, from, I think, 1 July 2020. And it also applied to previous years as well, if UPEs arising from between 2020 and 2019 were not treated as deemed dividends or placed on the terms of a Division 7A compliant loan agreement. So will they update the dates?
Yeah.
It's been a lot of slippage in time.
And there was a lot of other complexities and controversial issues in that discussion paper as well. So I guess it's a question, and, we're not going to be able to answer it now, but whether or not those are looked at, whether we get a comprehensive thing, or do we get a Band-Aid, or do we get no changes?
I mean, it's not like the legislation is not comprehensive. It does deal with UPEs in the subdivision EA context, in the non-retention situation, and there's scary, and we won't talk about it, 100A stuff that could potentially apply in retention scenarios. So it's not like there's a gap in the law. It's about whether it actually is, whether the legislative regime is deficient in some way. And I think the consultation paper highlighted what the Treasury considered to be 5 key deficiencies. And we'll have to, one of them including in respect of UPEs, and we'll just have to see how it plays out. Yeah,
I think that's well put. So, Chana, we've been talking about Division 7A, Bendel, what implications that have. If I'm an accountant or a business owner, what questions should I be asking, and what issues should I be considering now?
So I'd immediately be, if I was a business owner, I'd immediately be approaching my accountant. If I have, private companies that I control, and I'd be, as an accountant, I'd be reviewing prior transactions between the company and shareholder and associates of the shareholder. For example, loans, UPEs, payments, forgiveness of debts, those sort of things. I'd also be looking at what arrangements might arise in the future. Trust distributions at year end, what's going to happen with the money afterwards. Be looking at what potential exposures are, potential opportunities to get money back, for example, because of the Bendel decision. And I'd be taking protective action as soon as possible or corrective action as required, be approaching potentially a tax lawyer for specialist assistance. This is quite complicated. As we've discussed, UPEs, just because they're not loans, doesn't mean you're not that doesn't mean you're home and hosed. Subdivision EA, very, very complicated. There's also 100A. There's also concepts such as distributable surplus, which we won't. There's a lot there.
Yeah.
So certainly move quickly. You don't want to prejudice your position because you've taken too long to act.
Yeah. Act decisively. Ask the questions. I think that's a great summary. Well, the two of us have been advising businesses, business owners, accountants on Division 7A issues for a long period of time, and we can remember all those dates. And if you're unsure how this case impacts your situation, I would recommend reaching out to Achana. Achana's got an excellent article on our website which delves into some of these issues and what practical implications they have. So I'd recommend checking that resource as well. Once again, thanks for your time, Achana.
Thanks, Andrew. It's been a pleasure.